Good afternoon, everyone. I'm David Glazer, and I'm Steve Beck. Well, actually, so if you were expecting Steve Beck, Steve was pulled away, and so he is not here, so I'm going at this alone. Very few announcements today. The next webinar on April 8th is going to be Teresa Thompson and Nora Olsen-Blufstein talking about social media. I've heard them do this talk before. It's a really good talk about all the stuff that can happen in Facebook and other things, all the issues that can come up in the healthcare context. So it's a good topic. Same time on April 8th. Like all of our webinars, you can get them on SlideShare. You will get, when you get copies of the slides, a link that you can go out and listen for free to the last 2 years worth of webinars. If you are crazy enough to enjoy this one, you can always send it to a friend. And finally, the internet slows down a lot over the lunch hour. If that happens to you, you can dial in, and I think we're having some issues here, so I'm going to ask Chad to just send out the whole thing again. There's a dial-in number along with the meeting number. You can see that in the lower right corner. If I'm breaking up, every week, about 10% of the people have issues, and unfortunately, we can't control that because it's just what happens on the slowness of the internet. So if you're in one of the unlucky 10%, you can dial in. I think it's helpful to know how your lawyer sees the world. And so when I was a child, I drove into Washington, D.C. I was 6 years old. It was like late 1972, and I saw this scene. And suddenly, everything became clear. For the first time in my life, I understood what the Watergate scandal was all about, because I could see there was the gate and there was the water. And what had been a very, very confusing scandal to a 6-year-old was suddenly abundantly clear. And that tells you something about how my brain works and my perception of things, and has absolutely nothing to do with ancillaries. We are now going to talk a lot about ancillaries. So some things to keep in mind. First, this stuff is hard, which often causes lawyers who don't know the answer to say no. I mean, the general training for a lawyer is when in doubt, say you can't do it. Now, there are some notable exceptions. A client asked me this week about a plan to operate a lab in a state, like say a state in the Northeast. It's a client in the Midwest. And the lab was saying, you'll lease space in our lab and you'll just bill for it. It'll be great way to make money. And this scares the socks off of me because I think it's hard to argue that you in the Midwest are supervising services happening in the Northeast. So sometimes, but a lawyer has written a very nice opinion blessing this arrangement. So there are exceptions to the lawyers often say no, but that exception is is somewhat narrow. Be a skeptic of all advice, including things I say here. I find this stuff to be incredibly difficult. If something I say contradicts something you know, push me on it. And push yourself. If you've heard something for years and years and years, don't be afraid to reject it and substitute it with information. State law matters in this stuff, and states pass new laws. So you got to keep your eyes peeled on that. I think our job as lawyers is to tell you what you can do. Now, what you should do might be different. I'm going to start off with a quick overview of the laws. We're not going to spend long on this. I think organizing a talk on ancillaries is really hard, and so I will pop around a little bit from topic to topic simply because there isn't a perfect organizational structure. But we'll start off with laws. So the Medicare anti-kickback statute and Stark I'll talk about a little bit more in a second. They're the kind of big federal laws that apply. There are also state anti-kickback laws, and then there are many fee-splitting provisions. And the fee-splitting provisions generally only apply to professional services, so they're not always going to apply to an ancillary relationship, but sometimes they will, and you at least need to think about it. And you might have a state certificate of need, or CON law. And then the Medicare billing and supervision rules. I left off of this, but probably should have included Medicaid rules, which are going to vary. It's really, I view that as part of the state law question because it's totally state specific. So the Medicaid rules for Hawaii and the Medicaid rules for Florida are going to be entirely different. It's a federal program, but really operated by the states. So just a quick note, couple notes on Lingo. So Stark, you can't go to jail for violating Stark. All that happens if you violate Stark is that you have to pay $15,000 a claim. Stark is not intent-based. We don't care what your intent is. If you've got a financial relationship where there are referrals for designated health services, then Stark applies, and you have to meet an exception. If you don't meet an exception, you have a Stark problem. But like I said, it's not criminal. The anti-kickback law is criminal. It's a felony if you violate it, and intent entirely controls. So whenever you've got a payment, and one purpose of that payment is to influence referrals for a federal health care program, then you've got a potential problem. There are safe harbors under Stark. You don't need to meet one, and you usually will not. So that's kind of the big difference. Stark have to meet an exception. Anti-kickback, you don't need to meet a safe harbor. One thing to keep in mind with the anti-kickback statute that I think is often overlooked, back when the first set of safe harbors came out, I want to say in 1991, there was a statement that said that payments within a corporation aren't covered by the anti-kickback statute. And that becomes pretty important to some of the things we're talking about. If you're a clinic or a hospital and you're talking about payments within the clinic or hospital, you should be able to basically ignore the anti-kickback statute. It's only when you have relationships with outsiders that that becomes a big deal. The only other thing worth noting here in Lingo is the tax exemption questions. We're not going to talk about that a lot, but if you're a tax-exempt entity, either a hospital or a clinic, you need to know that there's private inurement out there, which is the idea that an individual is getting some benefit from the tax-exempt organization, and both that individual and the organization itself are potentially subject to sanction. All right, certificate of need stuff isn't present in every state. Somewhere around 37 states have some sort of certificate of need. They cover different animals. Some have dollar thresholds, $1 million, $5 million. Some apply only to certain services. Some apply only in certain settings. So you need to know your state law. I want to spend a moment just thinking about the policy, because I don't understand why CON still exists. It really should be gone because it's an artifact of cost-based reimbursement. It comes out of a time when if you built something, you would get reimbursed for it, whether it was used or not. It's strange because it would seem to kind of create and encourage monopolies. So the idea of CON is we don't want, 2 scanners or 2 proton beam accelerators in the same market. But that's going to kind of get rid of competition. We're in an interesting place now. Insurance companies sometimes like them because it is a form of rationing. In some ways, you're limiting the available amount of resources, and so it can create a natural rationing. I encourage people to try to challenge the policy behind CON. Republicans should hate it. And if you're a free market fan, you should not like the idea of a CON. If you do have a CON, look at the exceptions, because often if you're trying to put in, say, an extremity scanner, it may be cheap enough that you can do it despite the presence of a CON. Some states, like I was doing stuff in Alaska, if it's in your office, there are exceptions that may allow you to use it. So there are often ways that even in a state with a CON, you can work around it. I think that's enough on CON. So state laws, beware of the, I think we've already covered these, except for one thing I often forget about, which is that many states require that you give notice to patients when physicians have any financial relationship in an ancillary. And that's something to pay careful attention to, because you will often be required to disclose to the patient that you have some sort of financial relationship. Big pictures on ancillary. So we're going to be talking about things that are either diagnostic or therapeutic. I actually can't really think of another bucket. When you're in the Medicare world, therapeutic services are often going to be incident to a physician's services in order to be covered. Not always, but usually. In a weird quirk, diagnostic tests aren't incident to. And this is going to be important for reasons that relate to supervision and also how you can provide credit in the compensation formula. So this is a semantical point, but one worth noting. Diagnostic tests are technically not incident to a physician, and that wasn't always clear. Medicare clarified it in, I want to say, either 2002 or 2004. When you're thinking about ancillaries, almost anything you do alone is going to be less risky than anything you do with others. Less risky doesn't mean it's legal, but basically, the more participants, generally speaking, the higher the risk. Another big picture point is that if you're rural, which means that you're outside of a metropolitan statistical area, and 75% of the patients who are using the thing are outside of a metropolitan statistical area, joint ownership is possible, and joint ventures are going to be a lot easier. In urban areas, it's going to be much harder to do joint ventures, and they're almost always going to require you doing one of two things. Either excluding Medicare and Medicaid from your joint venture, or having the venture be in a building where all of the participants are located and have offices. There might be some exceptions to that, but that's kind of a general principle. And so if you're thinking about it, rural, joint ownership can work. Urban, you're probably going to need to be in the same building. It's worth noting that joint venture can mean different things to different people. Joint ownership is going to be more problematic often, but there might be other ways of skinning the cat. In April 2003, the OIG came out with a special advisory bulletin scrutinizing joint ventures, and they really don't like turnkey relationships. They don't like a situation where an organization is saying, we will provide to you the service we normally provide. So I'll pick on lab for a minute. Hi, we're going to come in and run your lab. We'll lease you the staff. We'll lease you the equipment. You just bill for it. They would argue that in a turnkey situation like that, any profit made by the person who's leasing the equipment and space is really a payment for a kickback, and that it's a mechanism for the regularly operating business to transfer profit to a referral source. I don't buy that. There haven't been a lot of cases like that, but you need to know that's out there and that OIG concept exists. And then the last kind of big picture point, obviously if someone gives you a deal that's too good, you should be nervous. And it's always helpful to think about, if you weren't referring them business, would they offer you this deal? And is the money you're making commensurate with your risk? That's hopefully old hat. All right, let's dive into substance. So here are some quirks for ordering and supervising tests. This is not a quirk who is ordering and supervising tests, but rather the quirks that come up when one orders tests. So Medicare has a rule that only the treating physician can order a diagnostic test. And this is another thing that can kind of get lost. A doctor who's out there can't say, oh, you can't internet prescribe diagnostic tests. You've got to be actually treating the physician, or be a treating physician. For purposes of ordering, the professional includes a wide variety of physician extenders, including clinical nurse specialists, psychologists, social workers, nurse midwives, nurse practitioners, and physician assistants if they're in the scope of license. So those are the folks who can order a test. This is bizarre, but supervising is different. And so even though the same regulation, which is 42 CFR 41032, sets out who can order and who can supervise, it then sets out different sets of people who can do the supervision. And so only a physician can supervise a Medicare diagnostic test. A non-physician practitioner can do certain tests, but they can't supervise them. Is this crazy? I would think so. It actually seems inconsistent with the statute, which allows physician assistants and nurse practitioners to do for Medicare generally anything that is inside the scope of their practice. But Medicare has been pretty clear that they think that they can't supervise the tests. Now, I talked about my new camera. If you look at this, these are some ospreys that I saw when I had my daughter down in Florida. I'm assuming that's the mom or dad. It's hard to tell for me to tell on ospreys. Looks kind of serious, and that baby is looking kind of angry, which brings up the question of supervision. All diagnostic tests require some level of supervision, and you get this out of the Medicare fee schedule. Every year, when the fee schedule comes out in October or November, occasionally as late as December, it lists every diagnostic test and then says what level of supervision is required. There's either general, direct, or personal. Actually, there are some that fall into category 9, which is no supervision required. But the easiest thing to do is you can look up your CPT code in that list and see the level of supervision that's required. Now, most therapeutic services are going to have to be Incident 2, which requires direct supervision. Not all of them do. Like, we'll talk about that. Therapy doesn't, for example. But let's talk about what the levels of supervision mean. So when we talk about general supervision, that means the physician has overall direction and control on the service, but the physician doesn't have to be present in any shape, way, or form. So this would say under the training of the non-physician personnel who perform the diagnostics procedure and the maintenance of the necessary equipment and supplies are the continuing responsibility of the physician. Now, what's weird about that, plain film X-ray requires general supervision, which means that the doctor is supposed to be responsible for the maintenance of the plain film X-ray. Is that the reality in any medical facility in the world? And I would say probably not. I guess they're responsible in the buck stops here sense of the word, but they're certainly not the person doing it. So this is a place where reality doesn't really jive that well with the technical wording, all right? I think the practical definition I would use is who would the tech go to if they had questions about a particular scan? And so you want to make sure that the tech knows that this person is your boss. And where this becomes a bigger deal is in a joint venture and you have different entities referring. If you've got a tech who's working for 3 different clinics, the tech has to know that this scan is being done on behalf of this particular physician. So direct supervision is required for some tests, especially imaging involving contrast media. And direct supervision means that you have the physician, and remember, it can't be a PA or NP, the physician is present in the office suite and immediately available to furnish assistance and direction throughout the performance of the procedure. Now, the question, what is the office suite, has been one that has been around as long as I've been a lawyer, over 20 years. It's not clearly defined. We know what it's not. You don't have to be in the same room. I like to use the 30-second test. That's sort of made up by me, but there are a few other sources. One is some proposed rules that came out in 1998 where, this isn't a rule, and the rule that was being proposed here was never adopted. But in the preamble, this is just some discussion from CMS, and they'd say a group of contiguous rooms should in most cases satisfy this requirement. That's weird to me because I would think it would do in all cases. We've been asked whether it would be possible for a physician to supervise a service on a different floor. We think the answer would depend upon individual circumstances that demonstrate the physician is close at hand. The question of physician proximity as well is a decision that only the local carrier could make based on the layout of each group office. For example, in a one-room office to be located on a different floor, such as where a physician practices on 2 floors of a townhouse. Well, this is not super helpful, and there isn't anything that's crystal clear. I like the 30-second test. This tells you what's little stuff is out there. And finally, personal supervision, which is required for some things like stress tests and a few other things. The doctor must be in personal attendance in the room during the procedure. And there's a numeric, the fee schedule uses numeric code. 1 is personal, 2 is direct, and 3 is general. Now, to make life really confusing, different sorts of entities can have different levels of supervision. So for example, IDTFs, which are independent diagnostic testing facilities. And if you're wondering if your thing is an IDTF or not, it has to get separately enrolled for Medicare. And I should be clear here, I am talking about Medicare rules here, and most of this talk is going to focus on Medicare. I want to reiterate, Medicaid or even private payers could have their own separate rules or guidance. So, in an IDTF, there are some additional requirements. One is that a doctor can only supervise 3 or fewer sites, and the supervisor has to be someone who evidences proficiency in the both performance and the interpretation of the type of tests that are being done. So there are higher levels of supervision requirements for an independent diagnostic testing facility than a clinic or a hospital. Which leads me to a thing that could go in other spots, but I'm sticking it here because it fits in with IDTFs. Imagine a scenario where you don't have a written order for a diagnostic test. Does that screw you up for Medicare? Are we toast? And the answer is not necessarily, especially if the service is not, let's get rid of my double negative, if the service is being done any place other than an IDTF. How do we know this? Well, on Halloween 1997, the Federal Register issued the IDTF rules, and there was a statement where Medicare said, we're putting additional rules on IDTFs because we think IDTFs are more likely to engage in fraud, and therefore we're establishing a specific written order requirement. And so they require written orders for IDTFs while they don't impose the same requirement on testing in physician offices. Now, I've seen a bunch of situations where tests in physician offices are denied due to a lack of a written order. I don't think Medicare has the authority to do that based on this Federal Register preamble, but I think CMS forgets that all the time. So this is just an interesting thing. If you're ever in a situation where you don't have a written order, I certainly wouldn't refund. And if Medicare is denying it, I'd point this out and appeal. Okay, one of the big questions we get asked is how can physicians divide ancillary revenue? And physicians often want credit for what they would say is their referrals, and that understandably makes people a little squeamish. But the fact of the matter is physicians can divide ancillary dollars, at least in certain settings. Now, there are restrictions. Stark is the biggest one, and it's going to set up sort of different criteria for the hospital and the clinic. Hospitals are going to be much more limited in their ability to compensate physicians for ordering ancillaries than a clinic will. State law you got to be careful of. You have to also recognize that how you compensate physicians can affect collegiality, congeniality too, but collegiality, and also create incentives you may not want for overutilization. And you have to be aware of your tax exemption rules. So Stark has an exception, the in-office ancillary exception. And I'm calling it the group practice exception here, but it really is technically the in-office ancillary exception. And in order to be, and that requires you to be a group practice. And group practice has a whole bunch of requirements, including things like you can't compensate based on the volume or value of referrals. There are some other tests too, and I'm not going to get into all of them. One of the biggies is that 75% of all of the services that are billed by people who are members of the group have to be billed by the group. And so, for example, if you enter into a PSA, a professional service agreement, and allow someone else to bill, like a hospital, to bill for services that are done in the clinic, and you hit a point where more than 25% of your services are being billed by that hospital, that can create trouble. Now, if a service is personally performed by the doctor, those services aren't referrals. So generally, a doctor can get credit for anything he or she does, him or herself. Designated health services are limited to Medicare and possibly Medicaid. That's a really complicated legal question that's it's not clear. There's at least one court case that says it does. There's arguments it doesn't. I think the safest thing is to assume it does. But so technically, under Stark, you can credit someone for ordering services for non-Medicare and Medicaid patients. I get super nervous about it, but you can do it. If you're wondering what the list of designated health services are, it's right here. And it's a long list. One of the biggies on there, everything that's inpatient or outpatient hospital is by definition as a designated health service. You can see the other services there. Now, Stark has an exception that I used to overlook too often. If you're in some sort of physician compensation group where less than 5% of all of the revenue comes from designated health services, and so remember, that's only Medicare and Medicaid, so it's the list of designated health services on the last slide done for Medicare and Medicaid patients. So if that's less than 5% of the revenue of the group, and no physician gets more than 5% of his or her compensation from DHS, basically you can blow off Stark for in the group stuff. And it's easy to forget that. And I used to think that no groups ever met this, but it turns out a fair number do. So this is worth checking if you're a physician group. Now, a lot of people think Stark requires equal division of compensation. It doesn't. If you are a clinic, you've got all kinds of options. You can take your ancillary money and pay it based on RVUs. Okay? Now, when you do that, you can't give the physicians credit for the designated health services they order, but as long as you carve that out, you can pay them based on productivity. If you want, you can pay them based on RVUs and services that would have been designated health services, but they're for private pay patients. I'm super nervous about this because if you screw up, it's a $15,000 a claim, but it's legal. That's the whole could-should difference. You can choose an allocation method that's fixed and advanced. I could say Lori Hartman, who's sitting down here with me, is going to get 20%, and I'm going to get 30% because I'm greedy. And if we fix that in advance, and we give some other partners 10% each, that's going to be okay. And there are reasons you might do that. Maybe the spine surgeon is going to do more PT but less imaging, and so we're going to just allocate our percentages ahead of time and stick with them. That's kosher under Stark. You could divide things equally. You could have some sort of seniority component. You could break the group into subgroups of 5 physicians or more and have different methodologies in each of those. And you can combine these in sort of any way you want. We'll do 30% equally and 70% based on productivity. So all of those work, and this isn't even an exhaustive list. In the hospital, it's a little tougher because Stark is going to say that you've got to have a fair market value restriction on your compensation to the physician, and that's going to be coming in tax-exempt hospitals, both out of Stark and the tax-exempt rules. In a for-profit hospital, you'd only have to worry about Stark. Doctors, you'll have to can maybe get credit for work done incident to in certain circumstances. And if the doctor does an ancillary him or herself, there they can get compensation. Now, if you do this a lot, there's a chart that appears in the Federal Register, and I stuck the site here. That's a useful chart because it highlights in the different Stark exceptions things that are or are not true. And it's interesting to look at, if you skip down to the scope of productivity bonuses, you'll see in different settings, different kinds of bonuses are allowed. So for example, in a group practice of physicians, doctors can get bonuses for things that include their incident to services. Bona fide employment doesn't include incident to. Weird, but it's the way Stark was drafted. And so if you can meet the definition of a group practice, you get more leeway in crediting physicians. You can credit them for things that are done incident to their services. Now remember, diagnostic tests aren't incident to, so they're not going to be able to get credit for MRI, but things like chemotherapy can be done incident to, and so you might be able to give credit for that. With another caveat is that there's a question of what if it's hospital-based. If you are a hospital, this is an important point, to be a group practice, you got to pay attention to things like, are you giving, well, in any setting, to be a group practice, you have to give patients the notice about advanced imaging, and so a lot of people that are nonprofits figure they don't need to pay attention to the group practice exception under Stark. And on some level, that's true, but if you're using the bona fide employment exception or the fair market value exception, you can't give credit for services incident to. And I'm hoping I'm explaining this pretty clearly. But use this chart and think about whether or not you can give credit incident to. Another interesting thing about this is the exception doesn't protect durable medical equipment. And this is extra confusing because people think about things like prosthetics and orthotics as DME. And technically, they're not. So they are prosthetics and orthotics, which are a different critter. DME is durable. It's equipment that can be used over and over. And with the exception of crutches, walkers, and manual wheelchairs, Stark is not going to let physicians own that in an urban area. Stark also carves out certain infusion pumps, whereas external ambulatory pumps are okay, pen pumps are not. So this is just stuff to note if you're in a physician group, what you can and can't include in the compensation formula. So if you are a physician group, you can't own durable medical equipment that you're giving to Medicare and Medicaid patients in an urban area. So you can do it for non-Medicare and Medicaid. You can do it in a rural area, but you can't do it in an urban area. All right, next thing we're going to cover here is the idea of sharing ancillaries. And this is complicated, and we're just going to talk about different ways in which you can share ancillaries in joint ventures of some sort. So first question, can you do it? Usually, yes. It depends on state law. The rules here are, there's no other way to put it, they're bizarre. You get weird things like if you've got an ambulatory surgical center, the ASC space has to be used exclusively by the ASC during their hours of operation. And so you can't put a scanner in an ambulatory surgical center space and share it. I think that's stupid, but it's there. There are special restrictions that deal with independent diagnostic testing facilities so that a clinic can't share space with an IDTF. A hospital can share space with an IDTF. Why? Honestly, I can't tell you. It's just there. So there are all kinds of crazy rules here, and we'll try to go through some of these things. If you can make it work, it is often quite profitable. So if you want to share therapeutic services, so let's say you want to do a physical therapy joint venture. If you're in a rural area, there's an easy way to do this, which is you just create an entity and you do it. You can have multiple entities, hospitals and clinics, more than one hospital, more than one clinic, can get together, you go in the entity, you split up the revenue based on the ownership. It's easy, it's low risk. There's really very little downside to this, except that if you're setting up a new entity, you might need to obtain new provider contracts. And when you're doing this, the revenue can only be divided based on ownership. So that's one angle that works in a rural area. Now, if you're in an urban area, you're going to be more limited. So there, a doctor is only going to be able to share with a hospital if the hospital is able to put the equipment in the clinic building, or you carve out Medicare and Medicaid. If you're in an urban area, you're going to have to be aware, and this is a slide we'll talk about in a little bit, the LLC you're creating can't be providing the service to the patient. And that means it can't do all of the work. It can only do some of the work, because otherwise it will be, for purposes of Stark, the entity. We'll talk about that in about 5 slides. You can allocate the costs amongst the people, but you're not going to be able to use a per-click lease for the equipment or the space if that assuming the doctors own the equipment or the space. You can use per-click for the staff. You can set it up so that each entity is billing for its own services. So say you've got an MRI, you put it into the LLC, it's in there, and then each of them operates the scanner and bills people for it using their existing contracts. Now, there are administrative challenges here. You're not going to be able to take advantage of higher hospital reimbursement that exists in some situations, and you're going to need to make sure that you meet the diagnostic test supervision rules. Now, whenever you do something like this, it's going to be covered under Stark's exception for space and equipment that requires exclusive use. And the Stark, so when they require exclusive use, CMS says that this, in effect, requires that the space leases be for established blocks of time. So one question that comes up is, can I lease someone my MRI for a scan? And the conventional wisdom is out there that you need to do it in blocks of time. People often say 3 hours. And they will point to preamble language like this, and then also the following one. A physician sharing a designated health service facility in the same building must control the facilities and staffing, for example, the supervision, at the time the designated health service is furnished to the patient. To satisfy the in-office ancillary services exception, an arrangement must meet all of the requirements, not merely in paper, but in operation. As a practical matter, this likely necessitates a block lease arrangement for the space and equipment. We note that common per-use arrangements are unlikely to satisfy the supervision requirements of the in-office ancillary exception and may implicate the anti-kickback statute. So this language is out there and causes people to say you need a block lease. That's wrong, because the real test is found in Stark, where you need exclusive use. Now, I bill by the 10th of the hour. If a client calls me up and asks me a question for 5 minutes, I'm exclusively working for that client during that 5-minute call. I'm going to hang up the phone, and the phone's going to ring again, and I'm going to talk to another client for 5 minutes. I am exclusively working for that client for 5 minutes. You don't need to have 3 hours in there for someone to have me exclusively. The notion that exclusive requires a block is simply untrue. And note that the language here is unlikely. The common per-use arrangements are unlikely to satisfy. Well, the question isn't whether it is likely to or unlikely to. The question is whether it does. And so if you can set up a situation where on a per-click basis, you're able to clearly delineate the space during this click belongs to this organization and this organization alone, you can meet the Stark exceptions and do things on a per-click lease. You just have to know that this language is out there and that the government is skeptical as to whether the supervision is real if it's in short increments of time. But when people say 3 hours, that's totally made up and arbitrary and based on nothing in any law, regulation, or other guidance. Now remember, we have those diagnostic test rules, and they say that a physician has to supervise the test. So can 2 tests that are, the MRI from 10 to 10:30 and from 10:30 to 11, can they be supervised by different people? And I would say yes, as long as we're being really clear to all the parties involved. And so this sets up the possibility of a shared overhead joint venture, where you take a scanner and Group A uses it 40% of the time and pays 40% of the cost, and Group B uses it 60% of the time and pays 60% of the costs. Now, the preamble seems to say that doesn't work. The rule seems to say that it does. All right, if you want to share diagnostic tests like imaging, in a rural area, you might want to set up an independent diagnostic testing facility. And, then you just run your scans through it. You divide the stuff on ownership. You even have the option of having the IDTF provide services to the hospital under arrangements which might get higher reimbursement. I am not as sure at this point. One problem with being a lawyer, I don't always know what the dollars that go with services are. I don't know that hospitals get paid more for much imaging than outpatient services do, but it's possible. The big negative of this is that IDTFs have additional rules like we talked about before. For example, they can't market. They can't do direct marketing to patients. So being an IDTF is a pain in the butt, and it can't share space with clinics and things like that. But that's an option in a rural area. And I'm not going to go through this in much detail. I've talked about this. This is just the idea that an IDTF can't share a practice location. It can't lease or sublease its operations. And it can't share diagnostic testing equipment that is used in the initial diagnostic test with any Medicare-enrolled entity except a hospital. Bizarre. If you read through the regulation, it is nearly impossible to understand. And it says things like you can't share a practice. And then the preamble said, this doesn't preclude an IDTF from leasing any part of its practice location to another Medicare-enrolled entity. And you go, that's exactly what the plain language of the rule meant. So this IDTF stuff is a mess. I generally try to avoid being in an independent diagnostic testing facility if you can. All right, a few slides ago, I promised to talk about the Stark and who's your entity. So Stark defines the entity as whoever bills for a service and whoever provides the service. And where this is important is in an urban area, if you are deemed to be providing a service, that's a big problem. And so you have to make sure that if you've got an LLC, it's only doing, it's providing just the equipment and not the equipment and the techs. If it's doing, the equipment and techs in an imaging service, it now for Stark is the entity, and all of the ownership limitations are going to apply. I did that really poorly. We'll save that for a rainy day. Can you do a per-click lease? A lot of people think you can't, but that's too simplistic. Stark does limit certain per-use leases, but it only limits them when the per-click payment is going to a doctor who is ordering the service. So an example of that is a doctor owns a scanner, leases it to the hospital, and wants to have the hospital lease be X dollars per scan. That is illegal under Stark. But if they could lease, the doctor in that situation could say, I'll lease you time on my scanner for X per month. That would be okay, as long as it's a fair market value rate. Or let's say the clinic or the hospital wants to lease a scanner from, say, a mobile imaging company. And the mobile imaging company is going to bring its truck up, and that company isn't owned by local physicians who refer. A per-click lease is totally fine there. So the per-click prohibition only applies when the person who's leasing, who is providing the equipment, is also ordering the service in question. Can two clinics in one building share a scanner? So first, if you don't do Medicare, the answer is yes, as long as state law permits it. Can two clinics in one building share a scanner for Medicare patients? Probably. If both of the clinics operate 35 hours a week, then yes, as long as we've got the supervision we talked about, and each group employs the tech during the time it's doing this. There are other models that might work, but this is the easiest. We've talked about the block lease issue. But so can two clinics in a building share a scanner? I would say generally yes. Now, We'll talk in a little while about what happens if the clinic isn't operating 35 hours a week. It's much more complicated, and I'm going to throw that at the end. You've got two clinics that are located across the street from each other. Can they share a scanner? Not if they want to bill Medicare. They could perhaps do private pay, but for Medicare, that's not going to work. It's arbitrary. It's just the way Stark happens to operate. Can a group lease time on another group's scanner? And if you're thinking about this, this is really the same question. And so the answer is yes, but to bill Medicare, they're going to have to be in the same building. Another very common question, can you accept outside referrals? And the conventional wisdom is no. The conventional wisdom is wrong. It's absolutely yes. A few states have limits. The biggest one is, the only one I can rattle off the top of my head is Florida. And Florida says that you can't accept more than 15% of your scans from outside people. But I don't know any state that prohibits it, and I don't really know any others that limit it. When people said no, they were basing that on language that was in the Medicare, I think, claims processing manual that used to say if a substantial portion of an entity's revenue came from outside referrals, the entity had to become an IDTF. Now, couple of things. First, if you're a physician group, there's no way that a substantial portion of your entire revenue was coming from outside referrals, because we're not just talking your imaging revenue, it's the entire revenue of the entity. Second, that language is gone. So this widely held myth is based on a misinterpretation of language that doesn't exist anymore, all right? Now, if you are accepting outside referrals, you need to make sure that any financial relationship you have with that outside referrer meets a Stark exception if they're sending Medicare patients to your scanner, all right? And this is true if you're a hospital or if you're a clinic. You know, if you whether you're a hospital or a clinic, if doctors are sending scans to you and you have any financial relationship with that physician, the financial relationship has to meet a Stark exception. So we were talking about the camera. Here is another example of it at work. Sometimes things just come out of the middle of nowhere. This was a humpback whale that I was lucky enough to have a speech in Hawaii and saw this. So the anti-markup rule for diagnostic tests, which has been around for a while, but was really changed, I want to say in 2008-ish, might have been 2009. So that regulation really limits the markup of diagnostic tests unless whoever does the test shares a practice with whoever ordered it. Sharing a practice basically means that 75% of their services are billed by the same entity. So in a clinic, you're going to be okay and the anti-markup rule doesn't apply. But if you've got two different clinics, you know, you're a radiology group doing tests, or if you are a clinic buying a test from a radiology group is a more accurate way of putting it, it's very likely that the anti-markup rule applies. Now, CMS is attempting to apply the anti-markup rule to both the professional and the technical component of tests. And that's a crock. As CMS explained, although Congress did not establish an anti-markup provision in the law, the omission may have been inadvertent. And this allows, so CMS says, since Congress made this mistake, we're going to apply the anti-markup rule to the professional part of diagnostic tests. They're wrong, and this is a really cluttered slide, but this is an actual copy of the law. And the law says here, so this is the anti-markup law, and it refers to a diagnostic test described in section 1861 S3 of the law. And if you look at what 1861 S3 is, it's actually here, that's diagnostic tests, all right? But if you go back to S1 is physician services. And I'm probably doing this a little too quickly, but the key point is under the law, physician services and diagnostic tests are different critters. And the anti-markup law only applies to the diagnostic tests. So CMS doesn't have the authority to apply it to reads, but they claim to. So what's the practical import of this? If you work with a radiology group, and the radiology group is doing reads off-site, Medicare believes that you can't bill Medicare more than you pay that radiologist for performing the read, all right? So if a read is done off-site, you can only mark up the amount you paid to the radiologist, according to CMS, if the radiologist shares a practice with the group. In other words, 75% of their services are billed by the group. I would contest this if I ever got in trouble on it, because I don't think they have the authority to do it. But from a risk management standpoint, I don't know that I would be running off to mark up purchased interpretations that are done off-site. Now, Medicare policy otherwise permits you to bill for reads that are done off-site as long as the contract that you have with that group allows Medicare to recoup overpayments from either party, and the person, the radiologist, has to have the right in the to see all the claims that go in. All right, but there's this weird anti-markup question. Medicaid is going to vary state to state, and you have to know your Medicaid rules. Now, there's another weird Stark trap that exists, and this is many people would say that Stark prohibits all off-site reads, and they base it on this language. They say that in order for you to be a member of the group, you have to be an independent contractor who's furnishing patient care services for the group practice under a contractual arrangement with the group practice to provide services to the group practice's patients in the group practice's facilities. And so they would say that the contracting physician has to be in the group practice's facilities. I think that that's a serious misreading of this language. I would say that as I diagram sentences, the person who has to be in the group practice's facility is the patient here. And that as long as the patient, I think this will work here. As long as the patient is in the group practice's facility, you're all right. But you need to know that there are people out there who say the doctor has to get his or her butt in the building. I think that's wrong. Okay. Next topic, surgery centers. Can you do a joint venture for surgery centers? And the answer is yes. Now, one question that's out there, I don't know if the reimbursement is better if you can do it hospital-based versus an ASC. I'm not sure. If you do a joint venture, you can get hospital reimbursement if you set up your ASC on the campus. And you can create a department of the hospital. And at least used to be true, you could get better reimbursement that way. I'm less sure whether the reimbursement is substantially better right now. The ASC can be placed anywhere if you're doing it as an ASC. The ASC Safe Harbor is narrow, but the risk of being a little bit outside that Safe Harbor, I think, is very low. So can you do an ASC joint venture? Yes. Stark isn't going to apply to it, so we don't really have to worry about Stark. The Safe Harbors here are really weird. You aren't going to meet all of the Safe Harbors. And I'll talk about some examples. Well, here, okay, one example. The ASC Safe Harbor that protects ASCs done by a hospital says that the ASC can't be located in a place where the hospital is in a position to refer patients to the ASC. And CMS has interpreted that as being the ASC must be outside of the hospital service area. No sane hospital will ever put an ASC outside of its service area. So by definition, you aren't going to be in the Safe Harbor. And I remember being on the conference call that CMS had when they came out with this, and someone said, well, but this is crazy. That'll never happen. I said, yeah, we know it'll never happen, but since any venture that's in the Safe Harbor can't ever be attacked by the government, we've intentionally made them extremely narrow. But remember, you don't have to meet the Safe Harbor. So instead, view the Safe Harbor as guideposts and go with some basic ideas. And to me, the basic ideas are you don't want to cherry pick your investors in the ASC based purely on referrals. Okay? So we don't have to worry about Stark. We're going to blow through that. The real thing to worry about, don't set up a system where you're paying primary care physicians, incenting them to send things to the ASC. You know, I don't want a bunch of primary care physicians as the investors in an ASC. I think that that's highly, highly suspect. So here's the Safe Harbor. I'm not going to go through all that. I just kind of talked about it. Another thing in the multi-specialty ASC Safe Harbor is what's called the 1/3 test. And you'll hear about this a lot. It basically says that 1/3 of every physician's medical practice income from all sources has to come from the performance of procedures. So in other words, they're a surgeon where at least 1/3 of their income comes from doing procedures, and at least 1/3 of each doctor investor's procedures are performed at the entity. And many ASCs have in their organizational documents a requirement that you meet this 1/3 test. So there's a very interesting question: what if you don't? Is it illegal? I would argue I don't think it is. But there's a principle here, and the principle is that you want the doctors who own the ASC to be invested in it, not in the economic sense, but in the practice sense, that they're really using it and that it's part of their practice. I think that's ultimately the real test, that the doctor isn't using it as a passive income source, they're using it as a place to truly perform services. So you can do ASC joint ventures. I actually think they're pretty low risk. You're not going to meet a safe harbor. If you're in a rural area, it's worth considering whether it's economically better to try to set it up as a hospital-based service. Now, another thing that comes up a lot in this setting, because these often involve a hospital, is hospitals will talk about the concern about the Redlands case, which is a case involving a tax-exempt hospital where the hospital got in trouble for participating in a joint venture that was a 50-50 joint venture. And hospitals will often believe that as a result of this case, they have to have 51% control of any joint venture. I think that is a misreading of the Redlands case, because in the Redlands case, the entire hospital was being placed into the venture. In a service line, we believe as a firm that you can do a 50-50 joint venture in a tax-exempt entity and it's defensible. Clearly, there are lots of them around the country. We do not believe there's that 51% requirement, but you need to know a lot of people will say that it exists. I think we've covered most of this. Anesthesiologists. I'm not worried about anesthesiologists owning an ASC because they are not in a position to refer. I don't want to have other non-physician surgeons who might be able to refer who own the thing. And as always, got to remember fee-splitting laws, certificate of need, anti-kickback, and disclosure. And I want to reemphasize disclosure because it's so easy for me to forget. Can you have multiple ambulatory surgery centers? Yes, but there are two buts. First but is, you've got this 1/3 test question. If you've got two of them, are you going to be able to meet the 1/3 test when you've got two surgery centers and a hospital and other places, maybe more than one hospital you do things? You won't meet the 1/3 test, and so you have to decide how stressed you are about that. The other thing, I've been asked this recently by several groups. You've got multiple surgery centers. Can you have one manager at both? And that raises potential antitrust issues. You have to worry a little bit if they are owned by different entities. If you've got two joint ventures, one with Hospital A and one with Hospital B, and you're managing them jointly, you want to make sure you don't wind up in a situation where you get in trouble for price fixing, where those two organizations are coordinating on establishing prices. Just an aside for the physician groups who are listening, something to think about is a divisional merger. This isn't directly ancillary related, but it is indirectly ancillary related because as you get bigger, you may be able to offer more ancillaries. And some of our more successful physician groups get anywhere from 1/3 to half of their income from ancillaries. And so if you're on the smaller side and are trying to figure out how can I get ancillary income, one option is a divisional merger. We could do a whole talk about that, but I just toss it out there. Another form of ancillaries is the physician-owned distributorship. And they're out there, they're getting some attention. There's a case in California right now where there are simply terrible facts. The physicians had a distributorship, and when asked by a hospital, do you have any financial relationship in this device, the allegations are that they said no, so they lied according to the complaint. Pods are an intriguing idea because they're an interesting mechanism for potentially lowering the cost of some devices. And so I'm intrigued by them, but I'm also scared about them. If I were going to do it, I would seriously consider having the physician own the device as part of their practice and not setting up a separate entity. Steve Beck and I put some thought into this. It's an interesting idea that's out there, and I just tossed that one out once again, that too could be a long thing, and we're running low on time, but just that's an interesting option that's out there. So physician-owned distributorships aren't inherently illegal. They're somewhat risky, and if you're going to do it, you've got to put a lot of thought into how you structure it. All right, lab is another ancillary. And a question we get asked periodically is whose name should go on laboratory bills? One of the things that has this question coming up for all diagnostic tests is now that Medicare is publishing a list of physicians who get the biggest payment. If you're the doctor whose name is on a lab, you're going to be on TV. The number one recipient of Medicare funds in Minnesota, I believe, was a lab director because all the lab services went out under his name. So a lab is a diagnostic test, and diagnostic tests have to be billed under the supervising physician, as you recall. Now, there can be multiple supervising physicians. You could have Dr. A supervising sometimes and B others. But you've got to choose someone who's really supervising, and lab director makes sense. So you may have a lot of claims going on under his or her name. And the consequence of that might be that they appear on that list of top Medicare recipients. There's nothing wrong with that as long as it's accurate, and in fact, I think it's the right way to go. But whose name should be on lab bills? Whoever's supervising them. Now, who can bill for lab services is one of the more difficult questions for a whole lab stuff. I think of as just hard, period. The relevant statute is 1833H5 of the Social Security Act. And the general principle is that a lab that performs a test has to bill unless you meet one of three tests. And the three exceptions are if the referring lab is in or part of a rural hospital, then that's one exception. If it can bill for tests that are done someplace else. If the referring lab is either wholly owned by or wholly owns or is owned by a third entity that wholly owns both the referring and performing lab, then the referring lab can bill. And the third thing is if you don't send out more than 30% of your lab tests, the referring lab can bill. Otherwise, only the lab that does the test can bill. Now, those exceptions are pretty broad and are often lost, and they're right in the statute. So just a note on time, I'll probably go about 3 minutes over, I think, based on what we've got left, maybe 5. So can I have different fee schedules for my lab services? And this is a question that comes up a lot in the pathology context. Anytime you have different fee schedules, I get a bit nervous. And I get nervous about the Medicare usual and customary issues. There are 2 advisory opinions, and I've got them cited here, and they come to somewhat, I don't know that they're different conclusions, but they set up a different analytical framework. So 9913 had pathology services, and they did not like, it was a situation where the pathologist offered significant discounts when charging other physician groups. They charged them less than they charged the Medicare program. They charged the Medicare program substantially more. And 9913 didn't like that. By contrast, another advisory opinion involving DME allowed a disparity between the price charged to other physician groups and to Medicare. And what they basically said is as long as the profit margin that the group was making on the Medicare business and the non-Medicare business was comparable, it was probably okay. And they said in particular, when you get to bundle bill another group, we recognize that's going to be cheaper than billing on a claim-by-claim basis to Medicare. So if you bill Medicare $100 and you figure it's 5% billing fee, if you bill $95 to a non-Medicare person, we're going to allow that and we won't hold that against you and we won't view that as you charging someone else less than you charge Medicare. Now, backing up a step, sometimes you can charge someone less than you charge Medicare. The Medicare policy is that you can't charge Medicare more than your median charge, the point where half of your people are paying more or less. So you could offer discounts to some, but you can't offer discounts so that Medicare is paying more than half of your other people. I like this profit margin analysis, but that means if you're charging $50 for your lab tests to a clinic and $100 for your lab tests to Medicare, I'm nervous about that. I'm really nervous about that. All right, therapy. So therapy joint ventures, remember both physical and occupational therapy are designated health services. So you're not going to be able to compensate doctors for ordering them. But you can set up a joint venture. Now, therapy is weird because you do not need to do it incident to a physician. So you don't need a physician on site, and you need to understand how you're setting this thing up. So let's say you've got 2 physical therapy locations. One's in your main clinic, and one is freestanding across town. Can you see Medicare patients in each clinic? Can you see new Medicare patients, and can you credit the doctor? So if you were billing incident 2, you can't see new patients because the incident 2, when I say new patients, patients who haven't seen one of your doctors to order the care. If you're billing incident 2, the answer would be no. But physical therapists can independently enroll in the Medicare program, and you get paid exactly the same whether your physical therapist is independently enrolled or not. So for physical therapy, you want to bill the service under the physical therapist's name, and they can independently enroll, and you don't need a doctor on site. The doctor's name isn't going to appear on the claim. You can see new Medicare patients, and all is good to go. And the only issue at all is that doctors will not be able to get credit for, in their comp formula, for having ordered that physical therapy service. But you can do it, and it's pretty easy. Now, if state law allows it, the physician can get credit for ordering PT for non-Medicare and Medicaid if you choose to go that route. And if you do meet the incident 2 tests, including billing under the doctor's name, then the doctor who is physically present when the service is performed can get credit for that work. And chemo is another place where this comes up. If I order chemo and Lori is present when the chemo is delivered, Lori's name should be on that claim, not mine. And Lori would get credit, not me, for that supervision. And so that's just kind of an important point. Now, this bird is illustrating the point that sometimes things have to be in exactly the right place. And this is sort of our last set of slides, which gets to where can you do services. So the factors to consider are supervision. Is it hospital-based? If it's hospital-based, you have to either be on campus, or if it's provider-based, you got to be within 35 miles. If it's Stark, you got to make sure you're in a contiguous state. And then there's this really complicated test for Stark. All services have to be in one of 2 things: a centralized location, or you have to meet the same building test. Centralized location is easy. Stark will let you put a service in any location that you control 24 hours a day, 7 days a week, as long as you can meet the Medicare supervision requirements. So you can have space across town if you have it 24/7, and you can, put your MRI there, you can put your PT there, as long as you can meet whatever Medicare supervision requirement is there. So for example, if it's an MRI, you need to make sure that when you use contrast media, a doctor's on site. But for other ones, you don't need a doctor there. So if you have it 24/7, things are easy. If you don't have it 24/7, then you're in the same building test. And these tests have given me a headache for years. And mostly I just put them in the following slides so you can look at this kind of at your leisure and try to figure it out. There's an easy one, which is if you have an office that's open 35 hours a week and you see patients at least 30 of those hours, you're good to go. The 2 that are harder are situations where, for example, you've got a doctor who's there 1 day a week. So, and this building is the place where patients primarily see the referring physician. Then there are 3 elements that you need to meet. And they are that the office is normally open at least 8 hours a week. The referring physician is in that office 6 hours a week. And then there's this biggie, which is that building is the principal place where the referred patient sees the doctor. So you can't have the doctor, you can't have 3 clinics in town and you're sending people from building A over to building B to get the scan done. They can only have 1 building there. And then there's this similar test. This is just the mud. I'm going to leave these up here. It's pretty rare to meet these things, and I mostly stuck them up here so people could look at them on their own, because these things put you to sleep every single time. So last slides are trouble on the horizon. These are sort of my storm chasing slides. People are always wondering, is all of this stuff going to change? And the answer is it might, but it might not. I am increasingly thinking it's not going to. Imaging. They've cut the reimbursement for imaging way down. I think the odds that Stark will prohibit in-office imaging are low, in part because it would require a dramatic change to how healthcare is rendered in this country, and so I don't see that happening. We've got a few questions here. So when you accept outside referrals for radiology or lab, you need to put the name of the referring physician in your on the claim. Can we put in any office doctor's name on this claim? Okay, there are really two boxes that you have to worry about. It's who ordered the test and then who's supervising. So for supervising in that one, you need to have someone who provided the level of supervision. So if direct supervision was necessary, you need the supervisor to be a person who was physically there. Ordering physician, you want to make sure you know who ordered the thing, and that should be somewhere on the claim. And unfortunately, having that wrong does allow the government to argue that the claim is inaccurate. So I would try to be right about that. Here's a kind of an interesting and difficult one. Can auxiliary personnel like a radiology physician assistant or radiology assistant, can you talk about them? What level of supervision is discussed? What can the radiologist bill for these professionals in the hospital, inpatient and outpatient setting? Well, there's a lot going on there, and I think I'm not going to dive too much into this other than to say, remember that the Incident to benefit doesn't apply in the hospital, inpatient, and outpatient setting. And so in the inpatient and outpatient setting, it's going to be difficult for a physician to bill for work that's done by a radiology physician assistant. In a clinic setting, you might be able to use the Incident to benefit, but in a hospital setting, that's going to be a heck of a lot more challenging. I ran over a bit, so I'm going to bring this thing to a close by noting that next session on April 8th will be about social media. If you have additional questions, you're always welcome to send them to any member of the Health Law Group. We're always happy to answer them. Thanks for logging in, and have a great day.